What is a covenant not to compete?
A covenant not to compete is a written agreement that expressly prohibits an employee from engaging in a line of work or a particular line of business after termination of their employment. It's to protect their prior employer from competition. It's also a clause that is sometimes found in a buy-sell agreement that prohibits the seller from competing with the buyer.
As an employer, when would I want or need to obtain a covenant not to compete?
It's particularly important if the employee that you're hiring is going to have direct contact with your customers or clients. The period of non-compete that is provided for in the covenant not to compete allows you an opportunity after that employee leaves to have a time to bring a new employee in and to train them and to get them in a good relationship with your customers. It's also important if the employee that you're hiring is going to have access to your proprietary information and basically learn how you do business, how you keep and retain customers.
What if I use an independent contractor, for example, to sell my goods? Should I require that they sign a covenant not to compete?
Unfortunately, a covenant not to compete is not a good fit with an independent contractor relationship. An important issue when you're deciding whether you're using the services of an employee or an independent contractor is how much control you'll have. With an independent contractor, you don't have the sort of control that would be consistent with a covenant not to compete. You should, however, have other provisions in your independent contractor agreement that will protect your proprietary information and would specifically require that the independent contractor not use your information, your customer list, or things of that nature for anyone's benefit but your own.
In the employment context, if I am the employer, what should I do if I want my employees to be bound by a covenant not to compete?
It's very important to understand that this is not a do-it-yourself project. This is definitely something that is worth investing the time and the money to have an attorney who is experienced in this area prepare an appropriate covenant. It's usually a provision within the employment agreement. It can only be enforceable in Michigan if it is drafted in such a way that it complies with Michigan statute. Otherwise, it is an unenforceable restraint of trade. So you've got to meet 4 requirements that are set forth in Michigan statute. Those requirements are, it has to specify the type of employment or line of business that the employee is prohibited from engaging in. That's usually the pretty easy step. It also has to specify a duration. For example, it might provide that the employee cannot do certain things within 6 months of the date of the termination of their employment, or it may say a year. It has to be specific. I've seen Michigan courts enforce as long as 3 years, but that is definitely on the long side of reasonable. Again, a court has to find these provisions reasonable. The third thing is the geographic scope. It has to specify a geographic scope. If it's a business with a fixed location, for example, a medical practice, and patients come to that location, the geographic scope is usually expressed by a number of miles away from the business, and it might be something that you can pull out a map and a compass and actually draw a circle and say the employee cannot work within that circle. With other sorts of businesses that are not so attached to bricks and mortar, that becomes a far more difficult task. It might not even be a specified geography in some but rare circumstances, and might instead really go back more specifically to the type of business or the type of customer context that they're prohibited from having. The last item is, and this is a very difficult one, but it must be a covenant that protects a reasonable competitive business interest. With any business, you have a variety of employees working for you, and some, for example, perhaps your janitor wouldn't have any contact at all with your customers. They might not really know anything about the way that you do business or what might give you a competitive advantage. So if they go to work for someone else, it would not be reasonable to restrain their ability to take another job, even with a competitor. On the other hand, your lead salesperson, who knows all your big customers, who knows what makes you special, who knows what all those customers want, in that situation, a covenant not to compete would protect a reasonable competitive business interest.
So these covenants need to be specific and meet a lot of requirements to be enforced. But what if the employer specifies that the employee can't compete for a 1-year period, believing that 1 year is reasonable, but the court disagrees and thinks only 6 months is reasonable?
That is a very unique aspect to covenants not to compete. Generally speaking, courts will not change contracts. They will enforce them as written. But unique to covenants not to compete, again, Michigan statute permits a court to effectively revise the covenant to make it reasonable and then to enforce it as revised. So if the court does think, for example, the period of time is too long, the court may instead say it needs to be a shorter period of time, and on that basis I will enforce it.
So how and when would a court get involved?
Right away. Typically, an employer finds out pretty quickly that an employee who has signed a covenant, who has left employment obviously, is working for a competitor. And again, there needs to be a competent attorney involved. They will file a suit. Typically, they will sue both the competing employee, and also their new boss. And they will very quickly seek a restraining order, because the objective here is to make the unfair competition stop quickly before you lose clients or customers and before you get into the very complex issue of determining what your losses are.
So shortly after the lawsuit is filed, the prior employee could be out of a job.
That's right. That is the harsh reality of these covenants not to compete, and that is why you have to meet these 4 very specific criteria. And there are some judges who, simply put, do not want to cause people to lose their jobs. So particularly with judges that are very sensitive to that issue, the employer has to be prepared for that reality and has to understand then that the covenant, if it's narrowly drafted to really protect that competitive business interest, but still give that employee some opportunity to go out in the world and make a living, it's going to be more likely to be enforced.
If I am considering hiring someone, should I ask if they have signed a non-compete?
Yes, definitely. And specifically if that prospective employee is someone who you know has been working for a competitor. If they're in any sort of sales capacity, it is likely that they might have signed a non-compete. And if they should suggest to you that they think they're going to be bringing a lot of customers or clients your way, those are all red flags that should very much make you ask about whether or not they signed a non-compete. And if they have, you need to look at that. And I should add, not only should you look at that, your attorney should look at that. This is another situation where it is not a do-it-yourself project. To get legal advice up front as to whether or not you should bring on anyone who has signed a non-compete is very important. You need to understand that you run the risk that if they are violating it or their prior employer thinks they're violating it, not only will your new employee get sued, you will be sued as well.